competing for you this afternoon. We have the University of Ottawa, who are behind me, as Claimant, and the Pennsylvania State University as Respondent. Ladies and gentlemen, we also have a very esteemed panel to hear this particular tribunal. Our chair today is Ms. Teresa Chang, SC, who is the Secretary of Justice in Hong Kong and took up that role on the 6th of January 2018. She's a senior counsel in private practice before joining government. She's also a chartered engineer and a chartered arbitrator, and has acted frequently as international arbitrator. She's a past Vice President of the International Council of Commercial Arbitration, a past Vice President of the ICC International Court of Arbitration, and particularly relevant to our hearing today, she's a past chairperson of the Hong Kong International Arbitration Centre. And so we're delighted to have Ms. Chang with us today as the chair. To Ms. Chang's left, as you are looking at the stage, we have Professor Margaret Moses. Professor Moses is the Mary Ann G. McMorrow Professor of Law at Loyola University, Chicago, and she's the Director of Loyola's Institute of International Law and Practice. She will be known to many of you as a book. Her book is on international commercial arbitration is extremely widely used and extremely popular. Margaret has also been a very long and very solid supporter of the Moot over many years, so it is a great delight to have her sitting on the panel as well. To Ms. Chang's left, her left, your right, is Professor Ulrich Schroeter. Ulrich Schroeter is a Professor of Law at the University of Basel in Switzerland. He too will be known to many of you as a book, because he too has published extensively in the fields of contract law, international trade law, arbitration, and various other aspects of commercial law. Professor Schroeter has been cited in decisions all around the world. It's a particularly poignant moment for us at the Moot that Professor Schroeter is on the panel, because we believe he's the first former Mootie to sit on our final panel. Now, I won't tell you what the Moot is. I think you've heard enough from me, so I will close my remarks now. You'll hear from me again at the end of the hearing, but I will now hand it over to our panel.
Good afternoon. This is the hearing for Falab Elemental and Black Beauty Equestrian. Now the tribunal has been properly constituted. I believe everything is in order, except that I'd like to ask the parties if you have had a chance to agree on how the matter is going to be proceeded with and the order of speeches. Have you had that opportunity? Well, shall we tell you what we are minded to do, but of course subject to hearing your views. We're minded to suggest we deal with first the procedural matter, and therefore the respondent to commence first, and thereafter on the substantive matter, and maybe the claimant to then commence first. And then I believe you know the time that has been allotted for each side, and I will very much leave it to you to decide how you wish to allot the time for each of the two sessions. And we are minded also to allow rebuttal and surrebuttal if that is something that you are minded to do. And again, that we will have to leave it to you to how you resolve on how to utilize the time. Is that agreeable to you, Claimant?
Yes, Madam Presiding Arbitrator, that is agreeable to Farlap.
Thank you. And Respondent?
It is Secretary Chen.
And indeed, if that is the case, we will proceed first with the Respondent on the procedural side first. Is that right?
Yes.
Now, okay, well, we have one or two questions that we may wish not so much as to start to ask you questions before you begin, but I think it will help you to know where we particularly might be interested in. For example, what you say is the substantive law. I think that's not in dispute, and I think there may be a dispute on what is the applicable law governing the arbitration agreement, and how does that impact on the powers that may impact on the substantive matters, and of course your reasoning reaching to those. We will no doubt have questions as we are proceeding, but I think those are the questions that we think specifically on the procedural side it will be useful for you to bear in mind. Okay. Thank you.
Honorable members of this tribunal, esteemed colleagues, good afternoon. My name is Alice Gently, and I, together with my co-counsel, Augusto Garcia, represent Respondent in today's proceedings. I will present the procedure of the case, while my co-counsel will address the merits of the dispute. We are before this tribunal today, asking for you to refuse to reopen this transaction by rewriting the terms of the parties' agreement. Claimant has commenced this arbitration, although all the goods under the contract have been delivered and the full contract price has been paid. Before my co-counsel, Mr. Garcia, explains why Claimant is not entitled to a price adaptation in the amount of $1.25 million, there are two procedural issues that this tribunal must address. And in that vein, I have two submissions. The first is that this tribunal should find that under the applicable law of denubia, it has neither the jurisdiction nor the power to adapt the contract. And the second is that it should not admit the partial interim award into evidence. Turning to my...
So let me just interrupt you for a minute. When you say the applicable law of denubia, could you be more specific? Are you talking about the lex arbitrii, or are you talking about the contract law?
Yes, Professor Moses. I'm talking about both the procedural and contractual law of denubia. So in this case, the tribunal should apply the Danubian arbitration law, which applies automatically, but also apply Danubian contract law to determine and interpret the parties' agreement.
All right. It would be helpful to know what the parties agree on. I assume you agree that Mediterranean law governs the sales agreement. Do the parties agree that the lex arbitrii of denubia is the law governing the arbitration, arbitration clause for the procedural aspects?
Yes, Professor Moses.
So the only thing that we're disputing here today is the substantive law interpreting the contract, is that correct?
Correct, Professor Moses. If I may further direct your attention to the contract which the parties actually agreed to, and direct your attention to page 14 of the record. In clause 15, we see that the parties have agreed that the seat of arbitration shall be vinda bona denubia. However, the parties did not expressly designate a law governing the arbitration agreement in particular. And because there is no express designation, this tribunal should in fact look to the parties' negotiations to ascertain which law the parties intended to have govern the arbitration agreement. To do so, the tribunal should refer to the case of Sul America Vienesa, a decision rendered by the English Court of Appeals in 2012. And in that case, the court outlined a three-pronged test by which this tribunal can use. To first look to the express choice of law. In the absence of an express choice of law, look to the implied choice of law, or alternatively, the law with the closest and most real connection to the arbitration agreement.
Can I then ask you, if you look at the express choice of law, as in the Sul America case, and indeed another one that follows that, one is looking at the choice of substantive law or procedural law. What do you say?
It's looking to the law that's actually provided for the arbitration agreement in particular.
And it doesn't say so in Article 15.
Correct. Correct, Secretary Chang, which is precisely why the tribunal should look to the parties' negotiations to see which law the parties intended to have govern. And to further elaborate, if I may direct your attention to page 33 of the record. This is an email sent from Respondent to Claimant on April 10th, 2017, and it's the first iteration of the parties' agreement. And in the first paragraph, the third line, Respondent agrees that the sales agreement shall be governed by the law of Mediterranean. And in the middle of the page, the bolded text, Respondent proposes that the seat should be Equatoriana, and the law of the arbitration clause should also be Equatoriana. However, on the following page, Claimant responds. On page 34, again in the middle of the page of the bolded text, we can see that Claimant removes the provision that applies to the applicable law to the arbitration agreement altogether. Instead of Equatoriana, it proposes that the seat shall be Danubia. And then in the line afterwards, it says that offer is naturally on the condition that the law applicable to the sales agreements remains the law of Mediterranean. Here, after we've gone through the express, and as you pointed out, Secretary Chang, we have no express here, we're looking to the implied choice of law. And if we look to both of these negotiations, we can see that there is no implied choice of law, primarily because the operative word in that sentence that I just read is remains, meaning that Claimant is referring to Respondent's proposal on page 33. And if we recall, Respondent only agreed that the law of Mediterranean would govern the underlying contract.
Counsel, a quick question. It does say on page 33 that the law of this arbitration shall be the law of Equatoriana. Isn't the law of Equatoriana the same as the law of Mediterranean? So why wouldn't that suggest that the parties agree on the law of Mediterranean as the law of the arbitration clause?
If I may clarify, Professor Moses, only in the first paragraph, the third line, does Respondent agree that Mediterranean law will govern the underlying contract. And this is merely their proposal that Equatorianian law will govern the arbitration agreement. However, that proposal is rebutted by Claimants on page 34. Therefore, our client's position is that we agreed on this page that Mediterranean law will govern the underlying contract and merely proposed that Equatorianian law will govern the arbitration agreement. But we do agree that it was rebutted. And therefore, in that sense...
When I would briefly follow up on that point, what do you make of the fact that the two exhibits you have just pointed our attention to differ in one important respect? In the first draft, the parties did not only agree, or one of the parties proposed a seat of the arbitration, but also specified that that law would be applicable to the arbitration agreement. The second draft is missing that specific designation, yet you argue today that by designating the seat, the parties wanted to apply Danubian law as the law at the seat. Isn't that somewhat contradictory because they had removed explicitly a clause to that respect?
On the contrary, Professor Schreiner, our argument here today is first that there is no implied choice of law because the parties weren't able to come to a consensus. So the first indication is correct. Although our client expressly designated a law governing the seat, Claimant did not agree to that and, as you pointed out, removed that provision. And we can see that there further is no implied choice of law, if I may direct your attention to page 35 of the record. In the middle of the page, we find the note from Mr. Antley, our client's former negotiator. And in the first bullet, it says, clarify an arbitration clause that neutral venue and applicable law. Therefore, as you correctly pointed out, Professor Schreiner, through these negotiations, it's clear that the parties were not able to come to a consensus, there was no common shared intent, and thus there can be no implied choice of law. But to your second point, because there is no implied choice of law, this tribunal should default to the law with the closest and most real connection to the arbitration agreement, which is the third factor which was laid out by the Court in Sudamerica. And in doing so, this is the fundamental logic which was laid out by the Court in C.Vis D. And if I may quote Justice Longmore, who delivered the opinion, an agreement to arbitrate will normally have a closer and more real connection with the seat as opposed to the underlying contract, because it is the seat that creates the procedural and contractual rights and obligations as between the parties and the arbitrators.
Counsel, I understand how it would create the procedural, there'll be a procedural closeness, but why contract? Why is the closest connection to a contract law when the parties chose an entirely different law to govern the contract, the sales contract?
The test under the Sul America test, Professor Moses, is actually the law with the closest and most real connection to the arbitration agreement, because that's precisely what's at issue today. I don't think either party is disputing that the sales agreement is governed by the law of Mediterranean. And so in order to determine which law should govern the arbitration agreement, the test should actually be the closest and most real connection to the arbitration agreement specifically.
No, I understand that, but what I don't understand, I understand why the Lex Arbitrii would be the closest connection, but I don't understand why the contract law of Danubia would be the closest connection.
When the parties agreed to the seat in this case, they agreed to the laws of the country of the seat, meaning Danubian arbitration law, as well as Danubian contract law to govern the interpretation. And this is further supported by the case in Dharmajaya Properties, where in that case, much like in this case, the parties agreed to a law governing the underlying contract and the seat, but did not agree to a law governing the arbitration agreement. And the court held that the most reasonable interpretation of that is that when parties select a seat, they also intend for that same country's contractual law to govern the arbitration agreement as well.
Would that necessarily hold true in our particular case? Because if we look at the negotiations between the parties, then it seems that various potential venues for dispute settlement were proposed at various stages of the negotiations. The courts in Mediterranean, the courts in Equatorial, the arbitration in Mediterranean, arbitration in Equatorial, and eventually the parties settled on Danubia. What they had done previously, and somewhat unusually, they had anticipated that there may or may not be the need for an adaptation of the contract. I'm not suggesting that they had agreed in this respect, but that was apparently on their mind. If we would read for your approach, wouldn't that mean that by designating Danubia, which I understand was mostly because the parties wanted a neutral venue, they didn't want to involve claimants' creditor committee, they would, by a sleight of hand, made it impossible for any adaptation to be ruled upon by this present tribunal. Isn't that not in accordance with the negotiations of the parties and therefore not a good solution?
On the contrary, Professor Schroeder, it is in line with the negotiations of the parties, as we can see through the correspondence on pages 34 and 35 particularly. Because we agree that the parties were unable to come to a consensus as to the implied choice of law, and that in fact the proper test which should be used is the last section of the test, which is the closest and most real connection, determining that the Danubian arbitration law applies without actually including Danubian contract law would actually provide for a situation where Mediterranean contract law, if applied in this case, Professor Schroeder, would be contradictory to the law which the parties have agreed to govern the procedural aspects, Danubian arbitration law. And if I may explain further, taking it to the second point on this issue, if we interpret the arbitration agreement through both Danubian arbitration law and Danubian contract law, as there is a symbiosis between the two, we will see that under both, this tribunal has neither the jurisdiction nor the power to adopt the contract. Namely, under Article 28.3 of Danubian arbitration law, in order for this tribunal to have the power to adopt the contract, there must be an express conferral of power. Meaning, according to Professor Klaus Peter Berger's argument, that express conferral of power requirement must be expressis verbis. So to your point, Professor Schroeder, it must, adaptation, appear within the actual language of the arbitration agreement itself.
So you read express conferral as written confer?
Correct, Professor Schroeder.
Can I go one step back about your choice or your arguments of the Danubian law? We understand that under the Danubian law, the straight four corners interpretation approach is to be adopted. Why are we looking at the negotiation history, first of all? And if we're not looking at the negotiation history, we just look at clause 15. Can you elaborate a little bit on, I think the question that I share with Professor Moses is the difference between the procedural law governing the arbitration and the law governing the validity, interpretation of the arbitration agreement, the lex arbitri, and strictly speaking in relation to procedure, as well as the other angle of the law, and that is interpretation of it. So can you help me on those points?
Yes, Secretary Chang. If I may answer your question in 2 points. First, to the issue of the Four Corners Rule, if I may direct your attention to page 52 of the record. And before I proceed, I see that my time has elapsed. If I may have an additional 2 minutes to answer your question and then go into my second issue. Thank you. In clause 2, we see that this is a list of conclusions that both parties have agreed to. And in bullet point 3, it says, as Secretary Chang pointed out, that according to Danubian contract law, which contains the Four Corners Rule, skipping down to the 4th line, there is a high likelihood that the arbitration agreement would not be interpreted as authorizing a contract adaptation. Therefore, under the Four Corners Rule, which is provided for under Danubian contract law, the only interpretive mechanism that this tribunal would be permitted to use is the language that's provided for within the four corners of the document, which is why applying Danubian contract law, in addition to Danubian arbitration law, makes the most practical sense as to what the parties intended by applying Danubian arbitration law, which isn't in dispute at all. And to go back to your first question, Secretary Chang.
But in order to support your point, you need to look outside the four corners, as you did earlier. So aren't you having your cake and eating it?
Circular argument, isn't it?
On the contrary, Secretary Chang and Professor Schooner, we merely look to the parties' negotiations to determine the applicable law because the ordinary conflict of laws analysis under the Hague Principles are not applicable in this case because it's an arbitration agreement. Therefore, because we're not able to use that ordinary mechanism, we invited the tribunal to use the three-factor test under Sue America.
Well, counsel, even under the Four Corners Rule, can't you use negotiations for clarification, just not for contradiction or supplementation?
Correct, Professor Moses. That would be Article 2.1.17 of the UNIDROIT Principles, which provides for the parole evidence rule. I should note that the parole evidence rule is merely an exception to the Four Corners Rule, and as you pointed out, it's only in the case of an ambiguity. And that would allow the tribunal to look to extrinsic evidence. However, even if the tribunal did look to the extrinsic evidence, and the pages that counsel for claimant will likely direct your attention to, pages 17 and 35, you will still find that the express conferral of power requirement under Danubian arbitration law is not met.
Just one last question. There is certainly some evidence in the record that the parties intended to provide for adaptation. So why should this tribunal believe that the parties would have intended to choose a law that would deny adaptation as opposed to one that would permit adaptation?
Professor Moses, to answer your question, if I may direct your attention to page 17 of the record, I think that's the page that you're referring to. And this is the witness statement of Ms. Julie Napravnik, which contains the potential indication that the parties intended to empower the tribunal to adapt. And here we see that our client's negotiator said that there should probably be an indication within the arbitration agreement or the contract for adaptation. However, Mr. Ampley says that it should probably be the task of the arbitrators to adapt, namely probably. And then in the next paragraph, it says this is only considered necessary in light of our tentative agreement on the issue. Therefore, after this negotiation, our client said that they may come back, probably, and claimant's own negotiator said that this was only a tentative agreement. Therefore, still, Article 28.3, the express conferral, is not met. If I may delve quickly into the second issue of the partial interim award, the partial interim award should not be admitted into evidence because it is neither relevant nor material to the outcome of this case, and in any regard, it was acquired illegally. To begin with the issue of relevance, briefly, the partial interim award is merely partial, and under Article 23.5 of the HKIAC rules, it may be modified or terminated at any time. Additionally, the partial interim award is neither final nor binding upon this tribunal. Further, the partial interim award was acquired illegally by claimant. Claimant attempted to purchase the partial interim award through a third-party source with a notably surreptitious reputation. And by virtue of the fact that Claimant had to pay for the partial interim award...
The standard Claimant has not yet paid, they're considering it.
Correct.
Counsel, what would be the harm to Respondent if this evidence was admitted?
In this case, Professor Moses, it would be against our client's specific confidentiality obligations that are tied to the partial interim award between our client and the other party in that case.
But confidentiality has been breached already, so doesn't that mean that this information is already in the public domain?
On the contrary, Madam Arbitrator, the public domain is defined in the WikiLeaks case, where that sphere of the public domain is actually the World Wide Web. In this case, the partial interim award is not in the public domain.
Public domain can be something other than being on the World Wide Web, can't it, Counselor?
Correct, it can, Professor Moses. However, in this case, the partial interim award isn't in the public domain because the way in which Claimant even found out about it was through an industry insider, Mr. Kieran Velasquez. So, and also had to pay $1,000 for the partial interim award. If it was in the public domain, it would be something that those other than industry insiders would be able to access, and perhaps something that wouldn't come at a cost. But the emphasis here is that they found out about it through an industry insider.
Can I just follow up on, you refer to the rules, of the HKIC rules just now. If you look at Article 45.3A1, there is an exception, is there not, to protect or pursue legal right or interest of the party. Now, of course, you may wish to argue who the party is as compared to the other party in the earlier part of the provision. But if we are to come to a view that the evidence that is sought to be adduced, illegally obtained, at least allegedly so by you, is relevant and material to the decision of the case, why can't we follow some of the investor state cases and still admit those evidence, because it might help us to protect or to ensure that the rights of the parties are either being protected or pursued?
To your question, Secretary Chang, if I may answer briefly in two different points. The first is that even if we look to the investor state cases, there the public interest is much higher than what Claimant would be able to assert today. Therefore, because the threshold is higher, here it wouldn't meet that standard. Further, to Article 45.3, there is an exception as to Claimant's ability to pursue their legal right. And we don't seek to deny them their legal right to present their case. However, they should be able to do so with evidence that's acquired legally. Additionally, under this standard, if I may quote the IBA rules on the taking of evidence, one of the exceptions to pursuing a legal right is legal impediment or privilege. And here, because the partial interim award was still subject to confidentiality provisions when Claimant attempted to acquire it, the exception to the legal right is legal impediment or privilege.
Was there not a case, okay, you say that the investor state may be a higher hurdle because of a public interest element, but I believe there is a case from CAS, which was dealt with by the Swiss federal court, which actually also admitted legally obtained evidence. So I presume sport is not quite as important as investor state?
No, Secretary Chang, not quite as important.
Oh.
But even if we look to that standard there, when this tribunal is considering whether or not to admit evidence that was illegal, it should also look to the potential ramifications of that admission, which is those that are provided for under Article 5 of the New York Convention.
Would you potentially be able to agree on sort of a middle ground if your client is concerned about confidentiality, and given the fact that your client has the option, the partial interim award, because he's a party to that proceeding, would you potentially be willing to make that award available only to this tribunal, for the tribunal's highest only, given the fact that under the HKIC rules, Article 22, it is up to us to evaluate the evidence, and we could potentially also order each party to produce documents. If we would not make it available to the claimant, but assess its materiality, wouldn't that be a workable middle ground?
On the contrary, Professor Schooner, because under the provision that applies for document production under the IBA rules, Article 3, Claimant would still have to submit a statement of relevance and materiality, as well as a narrow and specific request, and the partial interim award is neither relevant nor material if it has no precedential value, is not persuasive, and doesn't have an issue preclusive effect. Therefore, the standard that should be met for document production still isn't met. To conclude, this tribunal should find that it should not admit the partial interim award into evidence, and because the law of Danubia governs the arbitration agreement, it has neither the jurisdiction nor the power to adapt the contract. Thank you.
Thank you very much. To the claimant.
Members of the tribunal, good afternoon. My name is Rida Malik, and together with my co-counsel, Mr. Quinn Giordano, we represent the claimant, Farlat Olivamento. We appear before this tribunal this afternoon asking that you award Farlat $1.25 million. We submit We submit that this cost of $1.25 million represents Respondent's fair share of the 30% tariff that impacted the contract between these parties. My co-counsel will expand on this issue and explain why Farlat is entitled to payment. However, before we can get there are two important procedural considerations for this tribunal. The first concerns its power to adapt the parties' contract and provide the remedy sought by Farlat. And the second concerns the importance of admitting evidence from Respondent's other arbitration to provide context about this tariff. I'll be using my time today to address these issues with you. Turning first to the issue of this tribunal's power to adapt the contract, I'd like to proceed in the same order as opposing counsel. And with that, it requires turning to the arbitration agreement itself, which is found on page 14 of the record.
Counsel, just a quick question. In your research, have you found any jurisprudence where a tribunal has adapted a contract post-performance? Or would we be the first if we decided in your favor?
You would not be the first tribunal, Madam Arbitrator, to adapt a contract post-performance, especially because under the applicable law and rules, our client did not have the option to not perform. My co-counsel will address this submission. Returning to the arbitration agreement between these parties, members of the tribunal, we agree that there is no express choice at Clause 15. However, we disagree with opposing counsel as to their interpretation of the applicable implied choice of these parties. The applicable applied choice of these parties should be the law of Mediterranean. We know this from cases such as Sul America of the English and Wales High Court, as cited by counsel on the other side, and we also know this from cases such as BCY and BCZ from the Singapore.
But what about our case? Because in our case, the parties had initially included a specific clause in one draft that would have specified the law applicable to the arbitration agreement, so they had maybe, or they had considered to make an explicit choice, and then they struck that very line out. Is it reasonable to assume that once the parties had decided not to make an explicit choice, they wanted to make an implicit choice instead?
Mr. Arbitrator, it is when you consider the context of this agreement. It's a bit odd how it was concluded. The first set of negotiators were injured in an unfortunate accident, which means the contract had to be finalized by a second set of negotiators who were looking to interpret the meaning of what the first set of negotiators had discussed. And I'll shortly take you to the exhibits at page 33 and 34. But it's important for this tribunal to consider that when deciding between the law of the underlying contract and the law of the seat, it's not an equal one-to-one analysis. We know from judgments such as BCY and Arsenovia, both of which applied the test in Sul America, that the implied choice of the underlying contract is a strong presumption in favor of the law that governs the arbitration agreement, and it cannot be displaced simply by the parties naming a foreign seat. So with that, I'd like to turn to that drafting history.
Most of these court cases actually did apply the Lex Danubia, didn't they?
The Lex Danubia.
Usually, most of these cases under Silverica actually ended up applying the law of deceit. They claim that it's a strong pointer, the clause about the applicable law applicable to the container contract, but in the end, the outcome was often different, wasn't it?
I'll push back.
And also, tagging on to the question that was just asked, also, of course, in Singapore, there is a directly opposite decision in First Link. And in Hong Kong, and this is HKIAC arbitration rules, the cases in Hong Kong, we also shed some light. The Claimant case, as far as I know, also seems to be in line with you. However, the facts may be a little bit different. So I'd like to hear how you analyze all these cases that you say point to one point when they are actually not.
I'd like to address your questions in turn. Now, Mr. Arbitrator, you're correct. In many of these cases, the court did consider the law of deceit as an important factor. But if we look to Sul America to begin there, the court only applied the law of deceit because in Sul America there was an issue with the validity of the agreement. Had there been no issue of validity of the arbitration agreement under Brazilian law, the court would have gone with Brazilian law, which was the law expressly stated in the contract. And if we look to Arsenovia, which applied the decision in Sul America, the court also used the law of the underlying contract, being Indian law, to point towards what the parties intended for arbitration. Madam Arbitrator, you referred me to the decision in First Link, in which Assistant Registrar Sean Young considered that the presumption should be reversed, that the court should begin by considering that it's the law of deceit that is the default presumption. However, BCY is a decision of the same level of court, Singapore High Court, and it came 2 years after the First Link Investments decision. In his judgment, Justice Chong at paragraphs 65 and 59 addressed First Link, and he stated that it is considered an aberration in what should be Singapore's view of the appropriate law to apply in the absence of an express choice. We urge the tribunal to adopt the reasoning of Justice Chong in BCY based on Article 2A of the model law, which speaks to uniformity and keeping in mind the international origin of the agreement.
Counsel, let me just ask you a question about the model, about the clause, which was taken from the Hong Kong model clause, but doesn't exactly reflect it. In your view, does the party's deletion of the words related to affect the power or jurisdiction of the tribunal to adapt this contract?
Not quite, Madam Arbitrator. Now, you're referring, I believe, to the fact that at page 33 of the record, Respondent sent a proposal to our client where they narrowed the HKIC clause. However, the only explanation provided is that they thought it streamlined the language. Now, this decision to editorialize what the Hong Kong Center...
It says it has narrowed down and streamlined, right? So these are two explanations.
That's correct, Mr. Arbitrator, and that would be very important for this tribunal to consider if we were looking at a dispute that did not arise directly out of this contract. But members of the tribunal, you're being asked to consider the applicability of Clause 12, which is a clause in this contract. So this meets the criteria of being a dispute arising out of this contract.
But does this dispute really arise out of a contract when the contract has already been performed?
It does, Madam Arbitrator, and again, my co-counsel will expand on this submission, but the contract has been performed under the terms that were agreed to by the parties in that instance when it was signed. Now, those terms of the contract and the surrounding circumstance have evolved, and this contract should be adapted to reflect the increased true value of this product, which has increased as a respondent is selling these doses, which was expressly prohibited by the parties, and is doing so in a new and created booming market that did not previously exist. That is why the value of this good has increased, and as such, the price should be adapted.
I do understand that that is going to be dealt with by very colleague at a later stage, but it seems at first sight, as my fellow arbitrator has pointed to, that you do not make the claim that out of the contract as it initially was concluded, you would have the claim that you now make. You want us to adapt the contract. So isn't that something that goes beyond the contract as it stand, or as it stood at the moment it was concluded? Now you want us to modify the contract. Doesn't the narrowing down and streamlining of the clause suggest that that may be something we're not authorized to do?
I understand the concern, Mr. Arbitrator, but this would be a problem if the parties had not included a consideration of hardship at clause 12 of the contract. If this tribunal had only to determine that the parties thought about hardship but didn't include it in the contract, then there would perhaps be an issue. But the word hardship is found in this contract and has been explicitly contemplated by the parties. I would also like to address submissions by opposing counsel on the issue of Article 28.3.
Before you go there, I'm still a little bit troubled on how we're getting into the clause 12 and the adaptation, etc. Because the very first question that we've heard arguments from the respondent and hearing from you now will actually more or less make or break the point, because I understand there is no dispute that if it is Danubian law, then your claim on adaptation would fail in limbo. If, however, it is the substantive law that you are contending, including applicable to the arbitration clause itself, that will then allow us the power, or grant us the power, to do the adaptation that you are seeking. So that's actually a very important question as far as I can see. But you took us to pages 33 and 34 of the negotiation. I'd like to hear a little bit about that, because looking at the draft on page 33, the original suggestion was HKIAC rules, administered arbitration rules, and then the seat Equatoriana, law, Equatoriana, and then 3 arbitrators English. Now then the claimant, as I see in on page 34, responded to it. You didn't change the use of the HKIC rules. And if you look at page 33, the HKIC model clause is very much actually entirely followed in the original suggestion from the respondent. In other words, not only is the seat stated, so is the law and the number of arbitrators, etc. So by the fact that you've actually taken out the law of the seat, the law of this arbitration clause, instead of just changing Equatoriana to Duramia, does it mean that you've actually decided to continue to use the seat or not use the seat? The question I'm asking also has in mind with the case that I'm having to want to hear from you about the Klockner case. Because in that case, the choice of law clause is a little bit different from what you have here. So it might be said to extend to the arbitration agreement. But I'm not sure I would entirely follow from that case to say that the substantive law that has been chosen would apply to the arbitration clause. I really want to hear your argument on that.
Madam Presiding Chair, I'll start by addressing your concerns about page 33 and 34 in relation to the agreement to arbitrate. Now, you're correct. Page 33 and 34 represent an exchange of proposals from both sides. What's important at page 33 to begin there is that Respondent has suggested a seat and a law of arbitration which would have in no way restricted this tribunal's powers to adapt the contract. This is in fact in line with the Respondent's earlier assertions on page 10 and 11 of the record, where Respondent initially suggested the supervisory jurisdiction of the courts of Equatoriana applying the law of Mediterranean. So from these two proposals we see that Respondent has demonstrated a repeated intent to allow the tribunal to adapt a contract. Their issue today is with the form. It's not with the content of this tribunal's ability to adapt if we're looking through the drafting history. You also addressed the HKIC.
we actually are looking through the drafting history. What do you make of Claimant's exhibit number C8 that you have submitted and that we talked about earlier? And when Mrs. Napravnik, who negotiated for your client at that stage, said, or wrote, I suggested to clarify that issue and to include an express reference into the hardship issue or the arbitration clause to avoid any doubts, irrespective of the fact that she thought it wasn't even necessary. So it wasn't really quite clear to the parties, was it?
It wasn't at that stage, Mr. Arbitrator, and I will address your question in just a moment. Madam Presiding Arbitrator, you also referenced me to the HKISC model clause. What's important is not just the model clause that's provided by the Hong Kong Center, but the note that goes below it. It puts an asterisk next to the law of the arbitration agreement and states that it is only required to be inserted where the parties intend for the law of the arbitration agreement and the law of the seat to be different from the substantive contract. Here the parties have demonstrated by removing any separate reference to a law of the arbitration agreement that they have intended, as noted in a long line of cases, that they intend the entirety of their agreement to be governed by one system of law. So it is in fact consistent with the suggestion from the Hong Kong International Arbitration Center on that point. To address your point, Mr. Arbitrator, you were referencing Ms. Napravnik's statement at page 18. Now, unfortunately, she never got the opportunity to include that express reference. She was unfortunately injured in that car accident, and her desire to include that express reference couldn't be communicated to the second set of negotiators who concluded the contract. They based their decisions on all the email communications. So if I'd like to take you back to page 33 and 34, I hope you won't object. Page 34 of the record in particular. Here we see that our client removed the reference to Equatoriana only because it's the law of the counterparty, and our client cannot consent to such an agreement. It replaced only a seat, and when the second set of negotiators considered these emails, they took portions from each of the communications. The reference to the number of arbitrators and the language comes from page 33, and the reference to the seat being Danubia comes from page 34. So they combined what they considered the essential elements from each of these proposals. What it also tells you, members of the tribunal, is that the second set of negotiators knew, from the example on page 33, that the parties could have selected a different law to govern the arbitration agreement, yet they chose to remain silent on that point. So we invite this tribunal to follow the reasoning in a line of cases, including BCY, to apply the law of the underlying contract, because it is a presumption that cannot be displaced simply by naming another seat. And to conclude on this point, at page 34, we also see that our client referenced that it could not agree to any contract that is subjected to a foreign law. Taking respondents' argument at its highest, which they have talked about in the response to the notice of arbitration, if we take the issue of separability, which is not applicable in this case because validity is not a question, but if we consider these agreements to be separate contracts, or even separable, then respondent was put on notice, as of the date of this email, that it could not have an agreement with our client that subjected it to a foreign law. Therefore, there was a common intent between the parties to subject this agreement to the law of Mediterranean to govern arbitration between them. So I would like to address one final point on this issue, and then turn to the issue of evidence admissibility.
Counsel, I have one quick question first. Just so I'm clear, the panel is clear on your position, you're saying that we do have the power to adapt because Mediterranean law governs the interpretation of the arbitration clause. But I have a question on Clause 12. Is it your view that Clause 12 confers power on this tribunal to adapt the contract irrespective of the arbitration clause? Is there a separate power there?
They are connected in nature, Madam Arbitrator, and we know this from the same scholar that counsel for the opposing side mentioned earlier, Professor Berger. He spoke to the distinction between these three laws, that the law of the substantive contract provides the criteria that have to be met to establish hardship. The law of the arbitration agreement is the basic source of this tribunal's power, which is granted to you under the law of Mediterranean, which we submit governs the arbitration agreement. And the lex arbitri is responsible for governing the procedure between the parties. So there is no issue between those laws in this instance. Now, counsel for the opposing side has stated that there is an issue, with the lex arbitri being denubia, as it restricts the power to adapt through requiring an express conferral. We have two submissions on this point. Firstly, the reference to hardship at Article 12 of the contract, which you just referenced, Madam Arbitrator, does speak to the parties' contemplation of adaptation as an appropriate remedy for a hardship should it be established. And second, what's important about Article 28.3 under the model law, which you can find on page 17 of the model law, if it's in front of you, is that the heading for Article 28 speaks to the rules applicable to the substance of the dispute between the parties. The rules applicable to the substance of the dispute between the parties in this case is the law of Mediterranean, which again provides standard to the parties the ability to have a tribunal adapt their contract. As such, there is no issue with the lex arbitri in this instance.
So in your view, you can separate out from, lex arbitri tends to have procedural parts and substantive parts. Are you saying you can just separate out the substantive parts from the lex arbitri and say that when the parties chose the lex arbitri, they didn't choose the substantive parts? Is that your position, counsel?
Not at all, Madam Arbitrator. When the parties select a lex arbitri, they are bringing along all the mandatory provisions of the procedural aspects of the arbitration law of that country. We are not disputing that Article 28 is a mandatory provision. We are simply stating that this tribunal should look to the purpose of Article 28, which is the only clause within the model law that speaks to the rules applicable to the substance of the party's dispute. And the rules applicable to the substance of this dispute are the laws of Mediterranean, as expressed at Article 14 of the contract. The last point I'd like to quickly address on this relates...
Just one more thing. If you said it's mandatory, so if we were to determine that 28.3 was actually embodied public policy, would we then be obliged to apply 28.3 of the lex arbitri of the Procedural model law?
Not as it applies in denubia, Madam Arbitrator, because any considerations of public policy under the model law, which would fall at Article 34 and 36 of the model law, require the tribunal to establish a ground or an objection in public policy only on something that is fundamental to that country's notion of justice. There's something we know about denubia. Danubian contract law also modifies the power of adaptation, but it only adds the words "if authorized," and Danubian courts remain unsure about the exact definition of "if authorized." So where the courts of a country remain unsure about how to interpret words like "if authorized," it does not rise to the level of being a public policy objection under the model law. The last point I'd like to address on this subject concerns counsel for the opposing side's reference to the term expressis verbis. This term was actually used by the Republic of Germany during the drafting of the model law, and it was considered that even though Germany objected to the addition of adaptation under the model law, they specifically stated, and I'll quote for you, "For modification and amendment to a contract, an agreement of this kind does not have to be made expressis verbis. Rather, it can be derived from the nature and purpose of that contract. The nature and purpose of this contract is determined at Clause 12, where we see that the parties have contemplated hardship." I'd like to spend just a minute or two of my time to address the issue of evidence admissibility, if the tribunal would grant me that time.
I think we... I think, given the time, and thank you, we've had your written submissions, we will read them and consider them. But perhaps just to address the point that has been raised by Claimant's counsel about the fact that the evidence is a provisional interim award and therefore it might be changed later. and therefore how is it relevant and material given its nature? Forget about, no need to deal with the illegality, you've had it all in your written.
To address the point of the provisional nature of an interim award, we're not saying that that award is in any way binding on this tribunal, just as no decision is. All we have is the power to persuade you in any regard. But the reason that that partial interim award is applicable and relevant in this instance is because it speaks to respondents' understanding of hardship. And that's something that would not be changed by the tribunal at a later point in time because it's based on respondents' submissions up until this time. We're concerned with respondents' different positions taken because even in their notice, the response to the notice of arbitration, at the end of the document, at paragraph 17, they speak to the fact that respondent would never agree to a contract where adaptation or this financial element of discretion is left up to the arbitrators. And yet we know that in this other proceeding, respondent has agreed to allow arbitrators to adapt a contract which includes an ICC hardship clause. We acknowledge that the ICC hardship clause was deemed too broad for this contract, but what's important, members of the tribunal, is that the ICC hardship clause does not explicitly provide for the remedy of adaptation. It speaks to other remedies, renegotiation, and termination. Yet, the respondent sought to receive adaptation. It clearly believes that adaptation is an available remedy to hardship. The other reason it is relevant to this tribunal's considerations is because, in that case, the clause for hardship used a higher threshold, 25%, to be excessively onerous. The threshold used in this contract, members of the tribunal, is lower. It only requires a hardship to be more onerous. If respondent believes that a 25% hardship for a company that is not financially endangered meets a higher threshold of being excessively onerous, then it cannot reasonably claim that a higher tariff does not meet the burden of a lower threshold.
It would not allow for this essentially mostly being advocacy on the side of the respondents, party representative, who obviously are in different positions or different law or different laws.
They are absolutely allowed to take different legal positions, but what's important here is that the understanding of hardship between the parties is subjective. The term has no objective standard in this case. It was explicitly designed for these parties in this contract. So respondents' understanding, particularly as put forward in an advocacy document, is important for this tribunal to consider. After you admit the award, we leave it to your determination to assign it an appropriate weight based on its relevance and materiality. We don't imply that this is a silver bullet or a smoking gun and that it will make all the decisions and allow you to go home. But it's one piece of the puzzle that is important for you to consider when determining hardship between these parties. For that reason, we ask the tribunal to find that the law of Mediterranean governs the arbitration agreement and that this evidence is both relevant and material to your considerations of hardship. Thank you.
Thank you. I think given the time, and we do want to hear the merits of substantive issues involved in this case, can I strictly, and I do mean strictly, limit the rebuttal to 1 minute on each side if you do want that. And then we do want to go into the merit side. We did touch a little bit about it just now, so over to you, Claimant.
Thank you, Secretary Chang. To go straighter into the issue of the merits, which is the crux of this case, adaptation, if I may direct your attention to page 57 of the record. Which is an extension of Clause 6 in the very beginning. Counsel for Claimant argued that because of the obligations and certainly restrictions that they have under their creditors committee, they're not able to agree to a law of the counterparty. However, if we see in the beginning of clarification 14, which begins on page 56, if I may read it verbatim, it says, in the context of a different contract, the creditors committee had declared that there was no need to seek approval for consent to arbitration clauses, Therefore, contrary to counsel for claimant's arguments, it could agree to a different law governing an arbitration agreement, and in fact, it has in this case. Thank you.
Thank you. Respondent?
One point on served by the members of the tribunal. Counsel for claimant directed you to clarification 14 on pages 56 and 57, but left out the rest of that sentence. It states, it does not need to seek approval only where the place of arbitration is in a neutral country. In this case, that place of arbitration is Danuvia, and it never needed to seek approval because the law applicable to arbitration is the law of Mediterranean, which is our client's own law. Therefore, no approval was needed or required. Thank you.
Thank you very much. I think we will move on to the next stage, and this time we're starting with the claimant side, please.
Members of the tribunal, good afternoon. My name is Kunjudeno, and I am presenting arguments on the merits on behalf of our client, the claimant, Barlap Alvamento. Now, we are here today because our client has paid the full cost of a tariff that was never its responsibility to begin with. Our client entered into what was anticipated and intended to be a long-term, mutually beneficial and profitable relationship with the respondent. But now, our client is taking on additional unforeseen expenses, while the respondent is profiting from reselling the doses. So the circumstances of this contract have changed, and it is for that reason, the changed circumstances, that we are requesting that this tribunal adapt the contract to restore its equilibrium and bring it back in line with the parties' stated intentions. Now, I have two submissions today. First, that the three criteria chosen to determine hardship under this contract by the parties have all been met. And second, that under hardship, the appropriate remedy in this contract with its applicable law is adaptation. And now, members of the tribunal, I know that there have been some questions in my co-counsel's argument about how exactly this tribunal can adapt the contract. So I want to begin by clarifying that to begin with. We know that the applicable law chosen for this contract is both the CISG and the law of Mediterranean. And we know from Procedural Order 1, Paragraph 4, that the law of Mediterranean is a verbatim adoption of the unit law principles. Now, we first must consider whether the CISG addresses hardship before we can refer to the applicable law. It is our submission that the CISG does not address hardship. It addresses impediment, which is a legally distinct concept akin to impossibility, distinct from hardship. And it is for that reason that we will proceed using Article 7.2 to the domestic choice of law chosen by the parties, which is the unit law principles.
Counsel, I just have a quick question. Isn't Clause 12 can it be construed as a complete derogation from the CISG? And if that's the case, then we don't get to 79 or the unit law principles.
Madam Arbitrator, to answer your question, the parties have not derogated from the CISG. It is our submission that the CISG does not address the issue of hardship. And for matters not addressed by the CISG, we refer to Article 7.2 to refer to the parties' choice of law.
What about the force majeure clause part of the Clause 12? Would that be a derogation?
The force majeure provision of the CISG provides a remedy of non-performance. And force majeure, or impossibility, we understand to be a legally distinct concept from hardship. We know from scholars including Franco Ferrari and Marco Torsello, as well as Larry Di Matteo and Professor Farnsworth, that impossibility may be interpreted more broadly, or rather impediment may be interpreted to include constructive non-performance. Instances not only where a shipment cannot be made, for instance because a dock is not unavailable, or the shipment will be about to go into a hurricane, but also where a financial impediment makes performance not possible. But under these circumstances, we are talking about the concept of impossibility, which is distinct from hardship. And I would like to direct you to the drafting history of the CISG to clarify that distinction. If we look to the Travaux, the 27th session, we will find that the Norwegian delegation proposed specifically the theory de imprevision, which would have been hardship as we know it. Now, the discussion of the delegates is clear that, in fact, this proposal, the Norwegian concept of hardship, was rejected. The delegates had the opportunity to consider it, and we know from paragraph 58 of the Travel that the Swedish delegation clarified they were not comfortable with what they considered to be a problematic inclusion of hardship. The solution they proposed was that the parties should instead determine their own approach to hardship and adaptation by including provisions into the contract or into the applicable law. That is the guidance we must take in this circumstance, to use what the parties have chosen amongst themselves, their own specific trigger for hardship in the applicable law, to take us to Article 6.2.3 of the Unit Law Principles, in which we have the adaptation remedy.
I understood from the arguments that your co-counsel made just a minute ago that she was saying that the parties have derogated from the ICC hardship clause. ICC hardship clause does not provide for adaptation, and I had understood that by including clause 12, the parties would have provided for hardship. So is the derogation a contractual one, or is it, now I understand it's a choice of the applicable law and derogation through that? Which of the two is it?
To clarify, Mr. Arbitrator, under Article 1.5 of the Unit Law Principles, the applicable law, the parties are capable of modifying the effect or varying the effect of any of the provisions under the law. We know that Unit Law includes its own trigger for adaptation. It is our submission that what the parties are doing here is not modifying or derogating from the CISG, but rather modifying Article 6.2.2 of the Unit Law Principles in the applicable law to have their own specific trigger for adaptation. And it is that trigger that is the three-part test outlined at page 14 of the record, if I could direct you there now, which states, at clause 12, in its relevant part, the seller shall not be responsible for, and then written in italicized writing, hardship caused by additional health and safety requirements or comparable unforeseen events making the contract more onerous. So what the parties are doing here is modifying the Unit Law Principles, which would have its own 5-part test for identifying hardship. The parties are including a 3-part test at clause 12. And I will now explain why each part of that test has been met and why this tribunal may then adapt the contract pursuant to the applicable law, the Unit Law Principles.
Before you do that, would you briefly explain whether it matters, in your view, that the parties in this particular case have decided to include the hardship phrase or description, as you say, into the force majeure clause that was in the boilerplate, I understand. Other risks they have regulated separately in separate clauses of the contract. Does it mean anything that this is a combined force majeure or hardship clause? And wouldn't this tribunal have to read the wording of the clause literally, saying seller shall not be responsible, because there's nothing about adaptation in that clause, or at least nothing explicit?
Yes, Mr. Arbitrator, we know as well from a plain reading of the clause that the clause states the seller shall not be responsible. Now, it does not clarify a specific force majeure remedy or a specific remedy of adaptation. While it may in fact be possible that there were other remedies available under this clause, for instance, that our client may not have been obligated to perform in instances of hardship, that did not preclude the applicability of the remedy we are seeking in these circumstances, which is the remedy available under the applicable law. Now, we know from the Procedural Order 2 that the parties did not give specific attention to the wording of the clause when they were writing it, and we can refer to page 56, paragraph 12, to confirm that the parties were concerned with page 12 of the record when they were drafting clause 12 of the contract. And this is important because page 12 of the record is the instance in which our client accepts a modified DDP provision. Now, this is critical because we know that DDP represents a maximum obligation for the seller and a minimum obligation for the buyer. Had there been no modification to DDP, our conversation this afternoon would be quite short because it would mean that our client was responsible for the tariff. However, our client indicates in no uncertain terms at page 12 of the record, and I quote, We are not willing to take over any further risks associated with such a change in the delivery terms. In particular, not those associated with changes in customs regulation or import restrictions. So it is in this statement that our client is clarifying they want a modified DDP provision, which would not include import restrictions and customs regulations. This statement is also important because our client is clarifying what it means by a comparable event under Clause 12. Our client explains a specific experience, an unforeseeable additional health and safety requirement. And we know from the procedural order 2 that that previous event involved a quarantine which cost our client up to 40% in additional costs. This was a government measure which had a staggering effect on the commercial viability of the contract. The parties were aware of this communication when they drafted Clause 12. And because they were aware, they could understand that this is what was meant by comparable, that the hardship provision would apply to two types of hardship, both health and safety requirements, which this tariff is not, and comparable, unforeseen events making the contract more onerous. We submit that the tariff falls within the latter. It is a comparable event because it is a government measure that has impacted the commercial viability of the contract.
But Council, health and safety regulations have such a different purpose from tariffs. I mean, tariffs deal with the economic protection of domestic markets. So because the purposes are so different, how can you say that they're comparable?
Madam Arbitrator, the purposes may in fact be different, but what we're looking at under this communication is whether the government measures would impact the commercial viability of the contract. And it's relevant to consider the other hardship provisions that the parties were addressing during their negotiations. In particular, as my co-counsel has suggested, the ICC hardship clause. The ICC hardship clause, we know, was rejected by the parties. The first negotiator for the respondent stated it was too broad. The second negotiator agreed. Why was it too broad? It was too broad because it would have been triggered, hardship in that circumstance, would have been triggered by any event impacting the contract. That would include third-party actions and government actions. It is our submission that the narrowing of the clause, Clause 12, comparability, narrows the events that would trigger hardship to government action. It limits the number of triggers from any action that would have been available under the ICC hardship clause.
But any government action would be included. Anything else? I mean, what risk remained with your client under the DDP? And we know that the number of risks were allocated to respondent by party agreement. So what risks actually remained with claimant under this contract?
Madam Arbitrator, by the distinction we're making, any risks associated with third-party conduct would have been borne by our client, and that is a broad risk.
Third-party, I'm sorry, I didn't understand what you said. Third-party contact.
Any third parties related to this contract, and we know that our client is involved in a sophisticated shipping measure. They're involved in shipping frozen horse semen, which requires certain technological expertise, including shipping in glass vials. If there were to be any mistakes associated with the shipping, any problems associated with the product, the method of transportation, those risks would be associated with our client if they were related to third parties, not if they were related to the government contract.
But wasn't that already covered by the hardship clause, failure of third-party service that already exonerated your client entirely on the hardship bid? So why include that into the hardship clause? In particular, if we look at the numbers, the parties renegotiated the price, and your client demanded 1,000 additional US dollars per dose and got 500. And we also know from the fact that 200 of those 500 additionally covered the extra transportation. So your client managed to renegotiate essentially a 600 price increase. And if we read correctly, if we follow your argument, they really took very limited risks for that. So was those 60% price increase a free lunch essentially for a client? Is that reasonable to assume, according to the negotiations?
Mr. Arbitrator, it is our submission that it was certainly not a free lunch. However, I see that my time is soon to expire, so I would request some additional time to address the remaining considerations.
Yes.
I would refer you to page 56 of the record, paragraph 8, to clarify precisely what was being negotiated with the DDP term. We know that no distinctions were made between the additional cost for DTP delivery and the price of the goods. And we know that while the removal of certain risks associated normally with a DDP delivery obligation had been used as an argument regarding the price, there is no specific clarification on the record that we can point to confirm precisely what that allocation of risk was. All we can rely on is what the parties have communicated, and that is why I have directed you to page 12 of the record. But there are still two remaining points on hardship that must be addressed for the remedy of adaptation to be available. The second is whether the event was foreseeable. Now, we know that the contract itself uses the word unforeseen, and that would be a lower threshold. However, we will not deny the fact that it is our client who uses the term unforeseeable, and so we submit that it is an unforeseeable standard under this contract. The CISG addresses foreseeability at both Articles 25 and 74, as well as Article 79, and we know from scholars including Professor Ferrari, Professor Ziegel, and Professor Fleckner that that standard is distinct from the common law standard of probability. So when we are assessing what was foreseeable under this contract, we must assess it using our Article 74 standard. What was possible in light of facts and matters. So I would like to clarify what those facts and matters were under this contract. We know that our client is based in Mediterraneo, and as counsel for Respondent will no doubt indicate, the president of Mediterraneo has a strong preference for protectionist trade policy. He was elected before the contract was signed, and he installed his super minister before the contract was signed. But I want to clarify for this tribunal. The tariff affecting our contract did not come from Mediterraneo. It came from Equatoriana. If we are to assume that the government in Mediterraneo, which is in favor of protectionism, will institute protectionist policy, by that same logic we must assume that the government in Equatoriana, which is in favor of WTO trade resolution and in favor of free trade, will also take the position that retaliatory tariffs are not possible.
I think given the time, I only have one question that I'd like you to help me on. You addressed clause 12 of the contract, and the wordings to us, I think, is seller shall not be responsible. So that's one thing. How does one go from there to your second point, which is the remedy is adaptation? How does one come from a clause that is effectively you're not responsible to an adaptation for a 1.25 million claim?
Madam Presiding Chair, it is our submission, precisely because we are seeking a payment of $1,250,000, this is consistent with adaptation. And I want to explain...
How do you get there is my question.
Yes, Madam Presiding Chair, it is not a simple clarification, so I would like to explain the parts of how we arrive at the payment of $1 million.
As succinctly as possible, given the time.
Yes. The commentary for the unit droit principles clarifies that in the event of restoring the economic equilibrium of the contract, we have to consider what the parties benefit from the contract and what the parties lose. Under these circumstances, Clause 12, as you pointed out, does not specifically assign the buyer responsibility for the tariff. It does not assign it to the seller either. Under these circumstances, if it had been assigned to the buyer, this would be a clear breach of contract, and we would be asking for a payment of $1.5 million. We are asking for the payment of $1,250,000 because we know that the respondent has breached the resale prohibition of this contract. They have taken a product at a value of $100,000 per dose and resold it at a value of $120,000. At a $20,000 profit on 50 doses, they stand to make $1 million in profit. If we take our client's loss, which is a payment of $1.5 million in the tariff, and remove the buyer's profit of $1 million, we are left with $500,000, which is allocated between the parties. On that calculation,
I want to cut you short a little bit here, because you're getting into the calculations and the details. But let me see if I've understood you correctly. You're saying that because Clause 12 allocates no obligation or no liability to either parties, and as a result of what has happened, therefore the equilibrium has been upset, and therefore you are entitled to a remedy that you are seeking.
that is precisely right, Madam Presiding Chair.
Then what's the point of having Article 12 then in the contract?
The point of Clause 12 of the contract is our party's modification of the trigger for hardship under the applicable law, which is the Unit Law Principles. The parties have clarified precisely what hardship means to them.
I understand you.
One brief follow-up question. Is your position that we should take into the calculation of the equilibrium the potential on-selling of the doses that have nothing to do with tariffs at all, that we feature in the gain that they make for that?
Yes, Mr. Arbitrator, we must consider the benefits that the respondent is taking in this contract.
Honorable members of this tribunal, esteemed colleagues, good afternoon. My name is Augusto Garcia, and today I will represent the respondent in the merits of the case. As was already pointed out by Ms. Janfi, the doses were shipped, the price was paid, and the contract was performed. In spite of these facts, Claimant has based its adaptation claim on a hardship clause, which is only a force majeure clause with a narrow hardship provision under which the only remedy is exemption from liability in case of non-performance. This is a shield and not a sword. To better address Mr. Giordano's argument, I will be making 2 points. Clause 12 of the contract is not triggered, and second, adaptation is not an available remedy. Turning to my first submission, I will be making 2 points. First, Claimant bore the risk of the tariff by contracting DDP, and second, Clause 12 of the contract is not triggered. At this point, I would like to direct this tribunal's attention to page 14 of the record, which is the contract as Clause 8. We can see at Clause 8 that the parties agree to the Incoterm DDP delivery to be paid, where the seller bears all the risks and costs involved in bringing the goods to place of delivery and clearing them for import. And for your question, Professor Moses, that which risks are involved in seller's burden, the tariff is included in this risk and in this cost. Therefore, Claimant bore the risk of the tariff. According to Professor Jan Ramberg in his book ICC Guide to Incoterms, published in 2011, when the parties agree to DDP, the seller has to pay all the taxes to be able to import the goods in the place of delivery, unless expressly otherwise in the contract. Because this is not the case, seller have the burden of the tariff and the risk.
The parties did not agree to DDP only, right? They did a DDP but clause and include the hardship.
It is true, Professor Schuller, that the parties agreed to DDP and to Clause 12 of the contract, and this guides me to the second point of this argument, that Clause 12 of the contract is not triggered, because Clause 12 of the contract is only in case of health and safety requirements. This is the hardship provision inside of the force majeure clause, where the remedy is not adaptation. But even if this tribunal considers that this clause provides for adaptation, we are going to analyze the hardship provision and the corresponding elements. We agree with counsel for Claimant that the Clause 12 of the contract provides for 3 elements that all have to be met in order to the hardship provision be triggered. The first element is that the event has to be comparable to health and safety requirements. In this case, counsel for Claimant has argued that tariff and health and safety requirements are comparable because both are imposed by governments and because both increase the cost of performance. However, if we take into consideration this element of the effect in decrease of cost, Then the third element of more onerous under this provision, which is a separate element, will be completely meaningless. Therefore, this cannot be a ground for comparison. We can also see that tariff and health and safety requirements have different purposes. While health and safety requirements are imposed to protect the well-being and the health of a population, tariffs are imposed to increase the revenue of the governments.
But counsel, let me ask you this. What do you think was claimant's primary motivation in this hardship clause? I mean, was it really concern about more health and safety requirements, or was it a concern on not losing money on this transaction?
This provision, Professor Moses, was added to the contract because of the previous experience with quarantine when seller tried to sell somewhere and increase the cost of its performance. Therefore, we can see that here the seller was worried about certain risks associated with additional health and safety requirements or comparable events where the duration and the cost of the test are uncertain, while in a different case, tariff is a fixed sum that a company may address if it's able to borrow it or not to be able to pay this amount.
But in fact, if I mean, there's a lot of evidence in the record that the claimant was very concerned about their financial status and that they were concerned about losing money. Given that, why shouldn't this tribunal give a broad interpretation to comparable as opposed to a narrow interpretation?
It's our submission, Professor Moses, that according to page 56 of the record, clarification number 12, if I may direct this tribunal's attention to. The intent of the parties was to narrow it down, the broad hardship clause, the ICC hardship clause that was negotiated, where any event that has an economic impact may cause hardship. However, the parties expressly intended to narrow this hardship clause to only events related to additional health and safety requirements.
But they didn't. That's not the only thing they did. They rewrote the entire clause. And if we look at the definition of hardship, and I ask opposing counsel, what do you mean? What do you make of the fact that the parties have included hardship into the force majeure clause, and not as a separate clause? Because we look at the clause, and it lists matters like missed flights and weather delays as force majeure. That seems a rather low threshold. Even a humble law professor like myself will have encountered numerous cases of force majeure in the last months, if that is what we're looking at. And shouldn't we have to read the hardship part in light of the force majeure that forms part of the same clause and therefore interpret it as really being a relatively low threshold?
Professor Schuner, it is correct that the parties added this hardship provision into the force majeure clause, but this was to protect the seller, because in situations of hardship, the remedy is renegotiations. However, the parties derogated from this remedy to have a higher protection for the seller, where the remedy is exemption from liability in the case of non-performance. Therefore, if the hardship provision was triggered, the seller was protected from the maximum protection that can be in the force majeure clauses, that is, exemption from liability in the case of non-performance. This takes me to the second element of the clause, that is the unforeseen characteristic. Counsel for claimant has argued that the tariff was unforeseeable, and we have to use the unforeseeable standard to be able to determine the situation of this tariff. However, counsel for claimant has contradicted itself when it directs this tribunal's attention to page 12 of the record, if I may direct this tribunal's attention back to me. Counsel for claimant has argued that tariff was included in the terms changes in custom regulation or import restrictions. The counsel for claimant has argued that it was specific enough included in this phrase to be able to be comparable, but was not specific enough for the parties to be able to discuss tariff and expressly did not provide for tariff into the hardship provision. Therefore, this is a contradiction of the counsel for claimant, and we also, from an objective standard, be able to determine that the tariff imposed by Ecuatoriana was foreseeable. In recent years, retaliatory tariffs have been imposed by diverse governments, and therefore, retaliatory tariffs are common in international trade. In recent years, governments such as Canada, the United States, Mexico, China, and also Ecuatoriana have all imposed retaliatory tariff before. Therefore, claimant, as was agreed by opposing counsel, as a sophisticated party in the international sale of goods, was well aware of the risk that it assumed when it contracted DDP. Now, I will throw...
I do read the facts correctly that Ecuatoriana had actually not imposed a tariff before.
If I may direct this tribunal's attention to page 15 of the record. 1-5. We can see that Ecuatoriana have imposed retaliatory tariff before in the second paragraph, which starts with, in the sentence starting with previous restrictions. It states, previous restrictions imposed by other countries affecting import from Ecuatoriana have, with one exception, never resulted in direct retaliatory measures. Therefore, we can see that Ecuatoriana have imposed retaliatory tariff before, and this tariff was foreseeable.
Anything that has happened once is foreseeable?
We can see that according to the facts of the case, Ecuatoriana have a complete restriction on the shipment of artificial insemination. However, this ban was rejected for temporary reasons to be able to import this frozen semen. Therefore, it was not Ecuatoriana a full promoter of free trade. And also we can see that before the contract was concluded, President Bukele had its campaign for a protectionist, and also from the facts we have this president of Ecuatoriana imposing retaliatory tariff.
Counsel, just so I'm clear on your position, you're saying that the trade, not only were the tariffs foreseeable, but also the fact that the tariffs would apply to this particular product, that was also foreseeable? Is that your position?
Yes, Professor Moses, because in this case we can see that the tariff from the Mediterranean was for agricultural products, and frozen semen, in the retaliatory tariff, frozen semen is categorized by governments such as New Zealand and Saudi Arabia such as agricultural products, and therefore it was foreseeable. The third element of the clause is the more onerous. Counsel for claimant has argued that because the commercial base of the deal was destroyed, the third element is met. However, the commercial basis of the deal has not been destroyed. The commercial basis of the deal was for our client to pay $10 million for 100 doses of legit semen and for them to be delivered DDP. Thus, the commercial base of the deal has not been destroyed. If this tribunal adopts the contract, then it will destroy the commercial base of the deal the parties agreed to. Therefore, we can see that the hardship provision in the force majeure clause has not been triggered. Now, I will address the second issue, that is the remedy. Counsel for claimant has argued that the CISD does not provide for hardship. We agree with this provision. However, we can see from the same travaux preparatoires of the history of the convention of the CISD that it was expressly rejected the situation of hardship. Therefore, professors such as Ferrari, that was quoted twice by counsel for claimant, have stated that there is no gap in the CISD. Now, if we are going to agree with counsel for claimant in this hypothesis that there can be a gap of the CISD, then we may agree that it can be filled by Article 7.2 of the CISD, and then the unilateral principles will be applicable in the present case. However, we can see that Article 6.2.2 of unilateral principles regulates the situation of hardship, where all the elements have to be met. One of the elements that is not being met is that the risk was assumed by the seller when it agreed to DDP, and therefore Article 6.2.2 of unilateral principles does not grant for hardship and not adaptation. But even if counsel for claimant states that the remedy will be in Article 6.2.3 of the Arbitration Principles. The official commentary of this convention states that the tribunal may adapt the contract if reasonable, but must take into account to be able to grant this remedy the risk allocation of the contract. In this case, the risk was allocated.
Which commentary is that?
It's a commentary of the Arbitration Principles in the Article 6.2.3. If I may quote the exact provision.
Yeah, if you have summarized it, that's fine.
Therefore, we can see that not even the applicable law grants a remedy for the claimant. In conclusion, this tribunal does not have the power nor the jurisdiction to adapt the contract and should not do so because there is no hardship and adaptation is not an available remedy. Thank you.
Counsel, I have just one quick question. This transaction is not exactly the way the claimant envisioned it, because the claimants did not envision that Respondent was going to resell doses at a 20% profit. Should this tribunal take that factor into account?
Professor Moses, first, there was no express prohibition in the contract for the reselling of doses. Second,
What about the on page 1 of the contract when they suggest that that they should be informed before other mayors are used?
there is an obligation to inform the seller if the use of the frozen semen. However, if claimant has any claim regarding breach of contract and damages, then it should be able to file a different claim for this remedy and not adaptation in the present proceedings.
Is it of any relevance to your case that, as you have outlined earlier, that the claimant had already delivered the goods to your client? Because if he had not, then it would be a shield, Article 12, Clause 12, and then you would potentially grant him. Can it really matter under the circumstances of our case, given that there were negotiations and talks between Mr. Shoemaker and the claimant about a potential adaptation of the price? Shouldn't we take that into account and not distinguish quite so strictly between cases in which delivery has been made and in cases in which delivery has not yet been made?
Professor Schuner, this should not be taken into consideration because first, the elements of the hardship provision were not triggered, and therefore there was not even right to withhold performance. And second, according to the unilateral principle, the same provision that counsel for claimant has argued, when the parties have performed, there is no ground for request of hardship, unless for adaptation.
Thank you very much. I think I will, again, given the time frame, can I ask the parties to confine to a 1 minute rebuttal as best you can? We'll start with the claimant.
Members of the tribunal, counsel for the respondent has misstated the record twice. These are our two submissions on rebuttal. First, counsel for respondent has stated that the parties did not turn their minds to import restrictions and customs regulations when they were drafting the hardship provision. But we know from the record that it was the respondent, not our client, at page 56, paragraph 12, that relied on our client's communications about import restrictions and customs regulations to draft clause 12. On our second point, counsel for the respondent has stated that because Equatoriana has implemented retaliatory measures once in the past, it must have been possible for our client to foresee the tariff. However, we know from page 7 of the record that one instance in the past took place under a national government, a separate government from the current government of Equatoriana, and we do not know by the record whether that government was a signatory to the WTO. Thank you.
I'll address the 2 points on Sorgo. First, according to page 12 of the record, there was protection for changes in coastal regulations or import restrictions and additional health and safety requirements. Only the third, additional health and safety requirements, were the ones the parties agreed to because it's the one in the contract. And second, counsel for claimant has argued and wants to prove with its own notice of arbitration without any evidence that this the statement of the government of Ecuatoriana and the parties in the political situation is true. However, this is not evident for facts. The facts are that the President Bukele was elected and was a protectionist before the contract was concluded, and that Ecuatoriana had imposed retaliatory tariff reform from the evidence of the record. Thank you.
Thank you very much. Well, thank you very much, Council, for the excellent submissions, which have really helped us in understanding the issues and allow us a difficult task ahead, and that is to consider the matter, and we'll let you know our decision in due course. So thank you very much, all of you.
Clearly yet another excellent version, another excellent file. Some housekeeping matters. Please, now leave.
Carlos, que ahí está ya para los